like.
All right.
Oh, like it's something, yeah.
Well documented. Good morning, everybody. We have a packed agenda. And I'm just going to say this off the bat. If you wish to testify, we do need a white card filled out. They are up here in front. We ask that you keep any testimony limited to the bills that are up at hand today. We also very gladly welcome any written testimony in lieu of live testimony. And we are going to first start with taking attendance. Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter.
Here.
Pope. Here. Arbit. Devendorf.
Yes. Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson. Here. Madam Chair, you have 12 members present. You do have a quorum.
Thank you. I will now take a motion from Representative Edwards to adopt the minutes from the previous meeting. Those are now adopted. Today we'll be taking testimony on several bills from Representative Pies as well as Representative Wozniak. They are House Bills 5404, 5405, 5525, and 5110. We previously had testimony on Senate Bill 351 and House Bill 5328. Those latter two we will be taking votes on. So I would first like to call Representative Pies as well as Senator Singh up to the table to testify about House Bills 5404 and 5405. I would note also that Senator Singh is with us as these two bills are part of a double set, and their identical packages are pending in the Senate, but we got to them first. So thank you and welcome. Tell us about the bills.
Thank you, Madam Chair and Committee. I'll be speaking to Bill 5525.
Can you start with 5404 and 5505 since we have the senator here, please?
Sorry.
He has other business to attend
Yes,
to
he
as well.
does. Thank you. Senator Singh invited me to be part of this package, and I believe he was acting on behalf of a constituent.
If you would like to defer to the senator, that is perfectly fine.
Thank you. I don't think I would know this process by now, and I don't.
Okay.
But perhaps he could speak better to the two bills than I could.
Okay, thank you. Welcome, Senator.
Well, great. Thank you very much, Madam Chair, members of the committee. As the representative said, we've been talking about these two bills, and there's obviously an additional bill now to the package. This was brought to my attention actually when I was a House member by one of my constituents, so I think you'll have a brief opportunity to hear from today on testimony. But our white cane laws and white cane laws in general were, promulgated in the 1920s throughout the country to protect those individuals that are blind and ensure that they had protections. We saw that even in the 60s there was more recognition on the federal level for those blind individuals and the protections of them. And what we're doing here today is looking at a set of regulations that have not been changed in decades. So currently right now, if somebody is driving a car and hits an individual who is blind, those are fairly low penalties. And so what we're trying to do is ensure that any violations of the white cane laws, the original piece is a misdemeanor, which is currently punishable by 90 days or a fine no more than $100. That actually increases now to $500 when there is no injury to a person that is blind. But in case of an injury, we are requesting that the misdemeanor, this would be a misdemeanor that would be no more than 1 year imprisonment and then no more than $1,000, or it could be potentially both. And then in the unfortunate situation of a death, that this would be a felony and punishable by imprisonment by no more than 15 years or a fine of $7,500 or both. And this also includes the death of a seeing eye dog as well. These provisions now will align with violations that happen in work zones, school zones, and other emergency zones, where those penalties for an injury to a pedestrian or a cause of death by car in those work zones and those other emergency zones, this would align these new provisions for those that are blind into those categories. So there's an alignment that are there. All 50 states have some type of white cane laws, and we are looking forward to updating this because it is something that hasn't been looked at for decades. And as you'll hear from, I think, a couple of the representatives of the blind community, they've been wanting to see these changes for a few years, and this was our opportunity. So thank you, Madam Chair, for allowing us to provide a little testimony and a little bit of background on those first two bills, and I know the next bill is also an important part of the package.
Thank you, Madam Chair, and thank you, committee members. When Senator Singh invited me to be a part of this package, this legislation regarding penalties, it prompted me to follow up with legislation with a wider reach for service animals and their handlers. I have a family member who is blind, and throughout my adult life, I've learned about the close relationships between animal and handler and services and the costs affiliated with all of that. I've also learned about the intentional actions that some people will take that ends up endangering the life of the handler or the life of the service animal. And I also realize that there is no civil recourse to address this problem and also for compensation. So, as I absorbed these stories, I was compelled to act and to make sure Michigan fills in the gaps to make sure there's full recourse. So our researchers did not find any statute that addresses civil penalties for intentional or negligent actions which render the service animal unworkable or dead, and does not address the resulting difficulties or adverse impacts of the owner handler no longer having necessary assistance and the financial impacts to the owner handler. This bill offers civil recourse. Our researchers found that there may be suits regarding service animals in some cases. However, they do not allow Michigan courts to recognize a cause of action for intentional or negligent actions, infliction of emotional distress, nor do Michigan courts permit the plaintiffs to recover expenses for emotional injuries and any related expenses that they have. So this bill recognizes service animals as more than just property. Right now, animals are considered only property in the state of Michigan. It's important because it acknowledges the unique role of service animals and aims to make the handler/owner victims whole by recognizing the varied and profound adverse impact of such losses. Specifically, if an owner's service animal is injured or dies, whether intentional or through negligence, this bill outlines civil remedies, which include retraining, costs of retraining, rehabilitation, veterinary services, equipment, attorney's fees, lost wages for the individual, and any emotional injuries suffered also. It also allows the plaintiffs to file an action if the defendant's actions are intentionally or recklessly or negligently cause the harm to the service animal. This bill is not for companion animals. It's only for ADA service animals as defined in Michigan Penal Code.
And Madam Chair, I just would say that I know we're also working with some stakeholders here to refine some of the legislation. They've not had the opportunity to look through this, but the fact that we're having a hearing sometimes brings some people to the table, and I know the rep and I are both looking forward to working with additional stakeholders to refine these bills as you go through your process here in the committee.
Thank you.
Thank you both so much. I note that yesterday in criminal justice, chaired by my friend and colleague, Kara Hope, we heard a package of bills about animal abuse. And so this seemed like a good opportunity for us to collectively and cohesively think about our furry friends. Anybody that knows me, they know I have a sticker on the back of my car. It says, "Tell your dog I said hi." I don't have a dog now. I'm still mourning my last one. But these animals are a part of our life, and I do think we do need to take action. And as you pointed out, Senator, there's nothing like a hearing to bring stakeholders out of the woodwork. And I do think some of the stakeholders that reached out to me and to both of you, one of the things that they brought up was changing a definition here from dog guide to service animal. And something that the Attorney General's office brought up was sort of how we have an incongruence of penalties here. And just as an example, it was pointed out that the penalties that you are proposing are the same as involuntary manslaughter, and maybe we need to try to even these out in order to make them fair and equitable across the board. So I really appreciate your willingness to work with the stakeholders. Another issue that was brought up possibly by the veterinarians was defining the word owner, because sometimes a service animal does not. And yes, Representative, you brought that up too.
Yeah, thank you so much.
So you're willing to work on that definition to make sure it is clear?
Yes, I've heard this from someone else also, from the family member I was just talking about. So I was informed about the necessary change that's needed for that. Thank you.
Okay. Well, I think we're all a little bit on the same page. I see we have a question from Representative Fink.
Okay, I have a couple of questions. I guess I thought we were doing these separatedly. So if you want to make me come back later or something, I understand, Chair Breen. Yeah, okay. Chair Breen actually already sort of made this point about involuntary manslaughter. I would just also note that there's a 15-year penalty in here for killing a guide dog, which is the same penalty as if a dog trained for fighting kills a person, or female genital mutilation, or burglary with use of explosives, or leaving a child unattended in a car and causing the child's death. So to me, that was the first hang-up I had on this legislation. If you're already intending to change it, we can move on from that point. But I do want to ask a question about what the mens rea or the state of mind of a person has to be. Looking at the statute as it exists, it says if you essentially would commit this crime by not taking all necessary precautions to avoid an accident or injury to a blind person, or evidently, I guess, the dog itself. So can you speak to, I mean, I've never seen a case like this. What state of mind does a person have to be in order to be liable for what would turn out to be a 15-year felony here?
Well, I think listen, if there's language that needs to be tightened up, like you mentioned, we are, I think, comfortable in doing that. I think what we're seeing here is that accidents that have occurred, as blind people are walking across the road, someone's not paying attention, they're texting, doing whatever. Those are the types of crimes that we're trying to address here, where an individual has not been fully functioning in their car and vehicle and now has caused damage, whether it's to the individual or to the individual's dog. That's what we're trying to address here, and that's what the white cane laws are already part of here in the state. And so what we're doing now is trying to add a penalty if you actually injure the individual or cause death to the individual, as well as the dog. And of course, on the dog, we put them all together, but I think there's a bigger comfort to changing, obviously, the death of a dog or an injury to a dog to a different level, and I think we're open to that conversation.
Okay, I mean, I appreciate that, and I'll be interested to see kind of how that develops. I guess the question I have about 5525, I mean, so this issue, for instance, of ownership. I mean, from your perspective, don't you want there to be as many people potentially on the hook as possible? In other words, who are you intending to make potentially the owner of an animal? Who, or I mean, what are you trying to accomplish here?
So that's something that needs more clarification. So I spoke with this family member who is blind, and it was suggested that I change the word to handler rather than owner. In my family member's particular case, They get their dog from Guiding Eyes, I believe it's called, in New York. Well, that school has a policy that you have to own the dog, that the dog works for you for 2 years before you can apply for ownership. So technically you don't own the dog. It's the person who's handling the dog, like a police officer would handle their canine. So that needs to be clarified there between owner and handler. I'm hoping that addresses something I did want to touch on also, when you were wondering about what kind of state of mind a person is. Well, this family member has told me that when she's been out on training, when got a new dog, there have been a couple of instances where some other people who were training with their dogs would have their dogs unharnessed by someone when they were like standing in a corner or something. The state of mind, there are people out there who believe that animals shouldn't work for humans. This is a little retaliatory measure, if you will, that they may do. So there's that kind of, I mean, not that they're the only people who would do something like that, but that kind of speaks to a reason that we wouldn't have thought of, that I wouldn't have thought of, that somebody would actually go and unharness a dog, which can endanger the person or can endanger the dog. So there's all these really various states of mind.
Okay. Just a very quick last question. Does the bill 5525, does it require, I guess, the fact finder to take into account the age or health of the animal that's been injured or killed?
As long as it's a working animal.
But is the, like if it's a 10-year-old animal versus a 2-year-old animal, is that required to be taken into account in determining the damages?
No, what only counts is that it was a working, functioning animal.
Okay, thank you.
Working in service.
Thank you.
I know Representative Wozniak has a question, but I do believe before we get to that, there is somebody to testify also, Robert Parsons. And there is somebody else on Zoom that I'm not sure who she is with, Carla Hudson, or either. They're both with you?
They're both with us.
Okay.
Yeah, and Carla Hudson is the individual who brought this to my attention.
Okay,
this
thank
issue,
you.
yeah.
Representative Wozniak, do you want to ask now, or do you want to wait till after the other testimony?
No, I'll do it right now.
Okay.
Representative, there's some opposition from two different groups. One is the veterinary group, the other is the insurance group. So the insurance group is complaining that this will make it too costly for people to insure their service animals. And secondly, it would be a disincentive to a vet himself to work on an animal that has no insurance. And I'd just like you to address those two comments. Or Mr. Singh, if you wish.
As Senator Singh said earlier, I, as well as him, are still working with some stakeholders. So I think those problems can be addressed. I wasn't aware of the insurance concerns, but I think that's important. I'm glad you brought it up. And again, we'll be talking with stakeholders about this.
Yeah, the insurance issue has just recently come up in the last day, so.
Thank you both. I believe both of you have other places that you need to be, and we have a few other folks to testify. And I know that we also have committee members that have somewhere else that they need to be too, so we're going to try to get through this quickly. On Zoom, I would like to call on Mr. Robert Parsons.
Yes, thank you. Can everyone hear me?
Yes, sir. Please go ahead.
Are you able to see me well?
Yes.
Awesome. Thank you. Good morning, everyone. Thank you for the invitation. My name is Robert Parsons. I am the state president of the National Federation of the Blind of Michigan. So the NFB of Michigan is the largest state consumer organization of blind people advocating for the rights of blind people in the state. So our tenets are to secure equality, opportunity, and security for blind people in the state of Michigan. We are one of 52 affiliates of the national organization of the same name. And I am here to discuss our support of this partnered bill between the House and Senate that's been proposed on the floor. I want to thank Carla Hudson for all of the great work and our Capital Region chapter for bringing this to Senator Singh. Just to give a testimonial, so I am a person that lost his vision. I lost my vision 11 years ago at the hands of a home invasion. My cause of blindness is a contractile closed head traumatic brain injury. And the cause of that came from a break-in in my home at the hands of gun violence. Someone broke in my home to rob my home, and in the midst of defending it, I was shot in the head. In that violence, and then in that evening, October 2013, I lost my vision completely. But in addition to that, I lost part of my hearing, and I also lost a few other senses, including some of my smell. So since then, I had to rebuild my life, which included having to start from scratch. I was a high school graduate, and that was all I had. So I worked in retail. So I started at the associate's degree level, and I sit in front of you as a Western Michigan University graduate student, specifically a PhD dissertation candidate, working on my dissertation in counselor education and supervision. I am one of only 4 licensed professional counselors in the field of rehabilitation and in counseling in general, specializing in career counseling. So I speak to you all as not only a guide dog handler, but also as a counselor specializing in disability affective counseling and specifically specializing in rehabilitation counseling. My passion is in working with people with blindness and low vision and in disabilities specifically on how to process acquiring disabilities and congenital disabilities and how to work through that in order to acquire what we call gainful employment in the field of rehabilitation, and how to be able to acquire that employment and use it to fulfill and live a fulfilling life. The reason that I do that is because in the field, in the community of blindness and low vision, for the last 2 decades, we've battled with the staggering fact that our community has a 70% unemployment rate. I use that fact to talk about our support of this bill because a contributing factor to that is blind people's aversion to travel. A lot of that travel is partially because of the fact that that is a challenge with the fact that motor vehicle and street crossing and what we call orientation and mobility has its side effects in that fear and aversion to being able to cross streets and be mobile outside in public has something to do with confidence, but also has something to do with safety. So a bill like this, which increases accountability for individuals who are motor vehicle operators, has profound benefits for not just the stakeholders like people like us that have blindness and low vision, but also for the sighted community and for the community at whole, because it promotes wellness and confidence in people with blindness and low vision to get back out in the community and become contributing members of society again. My work as one of 3, I repeat, 3 LPCs in this state, only 3 of us are licensed that are non-visual, that are blind at all, is to make sure that we can promote blind people to be contributing members of society again and get back in the working field. And some of that does fall on us to be able to get blind people working, get blind people out in the field. But that does come with being able to make sure that all folks out there are being able to take accountability for the actions that are taken. I am a guide dog handler, and I got my dog from Guiding Guys, which is one of the schools that was mentioned during the discussion that the representatives were having. And the representative, I commend her for the information she gave, because she's absolutely right in that handlers, which we are called, some of us don't own our dogs and our guide dogs. And when we get them, there is a sentiment from our sighted counterparts in public that shouldn't be having them work. And sometimes we have to educate and do active education to our sighted counterparts that they're working. So there are diversionary tactics, and these are from pedestrians, let alone from motor vehicle operators, that can cause safety concerns for us while we're crossing, while people are on feet. So this ability to make sure that motor vehicle operators are being safer while we're crossing helps us to make sure that we're being safe when we're crossing, whether it's in construction zones and school zones, which I frequent at Western as both a graduate assistant and instructor, as well as a student. And I thank you all for the opportunity to make sure that we're not only providing a symbol of multicultural awareness on campus because I teach courses and take courses. So bringing my guide dog on campus promotes awareness for individuals that are driving, individuals that are students, individuals that are teachers, that the blind have a place right next to you and I, but also that we deserve to be able to walk the streets safely. We deserve to be able to catch a bus safely, and we deserve to not get hit by cars. And if we are in a position where something like that does happen, because unfortunate accidents do, that people are held accountable and are held to the same standards as they would be in other states, as they would be in states that take this as seriously as they should. Because the decades-long time it took for action to be taken on a bill that has been in place since Lyndon B. Johnson was president is a bit of a long time for it to be not addressed. So I thank you all for the consideration, and I hope that we're able to take this testimony and take it further. Thank you.
Thank you, Mr. Parsons, for your testimony. I don't see any questions from the committee. Thank you very much for bringing this forward, and we're going to continue working on these bills. And if you have any input or insight, I encourage you to reach out to the sponsors. Thank you. Before we move on to Carla Hudson, who is on Zoom, I would like to call up B. Friedlander to testify on behalf of Attorneys for Animals. Thank you, ma'am. And just so you are prepared, I'm going to ask that you try to keep this to the same time as the other folks, which is just around 5 to maybe 7 minutes at the most.
Certainly.
Thank you.
Chair Breen, committee members, and Representative Pies and Senator Singh. I'm B. Friedlander, and I am the president of the board of Attorneys for Animals, which is a Michigan-based nonprofit. We comprise animal advocates and legal professionals. I've submitted testimony, so you should have that available. What I want to focus on this morning is to put this in context by looking at other states and to dispel some concerns about how these animals are defined and to compare them to emotional support animals, which this bill does not cover. As was mentioned earlier, all states except 5 seem to have criminal penalties for interference with service dogs. This is according to a report last year from the Michigan State College of Law Animal Legal and Historical Center. We've talked about the history of this. Another date I would put forward is 1990. And service animal has been a legally recognized concept since then, which was when the Americans with Disability Act passed. And basically that act prohibits public entities and certain places of public accommodation from discriminating against persons with disabilities, and requires that they allow service animals to accompany persons with disabilities in the areas where the public is allowed. As I mentioned before, the definition of service animal is limited. It only, in the federal statute, the ADA, it only applies to dogs. Miniature horses have been added to the federal bill by regulation, or the federal Americans with Disability Act. In Michigan, we define service animals as 2 animals, dogs and miniature horses, and that they have been individually trained to do work or perform tasks directly related to mitigate the handler's disability. Over the last several years, there's been a lot of talk about emotional support animals and a lot of, I would say, maybe near hysteria, snakes on planes, and primates as emotional support animals. We are not talking about this here. Service animals are not emotional support animals. A number of states, again referring back to the Animal Legal and Historical Center report, a number of states have both criminal and civil penalties for harm to service animals. And more specific to this bill 5525, there are 3 other states that authorize non-economic damages for harm to service animals, as would 5525. And if you look at what these states are, they're Illinois, Massachusetts, and Utah, which span a variety of geographic areas and a variety of political politics, I'll put it that way. So that's what I have to say. We are in support of this bill. We're aware of the amendments and do not at this point object to seeing further work on the bill. I'm willing to answer any questions you may have.
Thank you so much for your testimony. Oh, wait, Devendorf has a quick question.
Very quick question. How does one use a miniature horse as a service animal?
I mean, honestly, I think we deserve a demonstration, but
Well, I didn't bring one, unfortunately. The fact that they're miniature and the fact, I don't know for sure, but I would say that dogs have various sizes. And if you look at the ADA and Michigan regulations, there are no limits on the species or the breed of dog who can be used for service dog. So I would imagine that the miniature horses are miniature enough to be about the same size as dogs.
thank you very much for your testimony. I'm now going to turn to Carla Hudson. And Ms. Hudson, I am sorry to ask you to keep it super fast, but we do have some members that need to leave. So I'm hoping you can speak to us quickly about the bills that we have before us today.
Certainly. Hi, I'm Carla Hudson, and I am blind, and so is my husband, Michael Hudson, and we reside here in East Lansing. I have brought this issue to Samsung's attention, and I appreciate that you all are looking it over and discussing it. And the law, as it stands now, is pretty antiquated, and so it is great to see you guys trying to update. And so the issues are, and I think Robert kind of went over them, but we have distracted driving, and people have lots of technology now in their cars. And although we have texting laws in the state, people don't seem to always abide by those. So that is one of the challenges. We also have a lot of quiet cars now on the streets that need to be addressed. And so that's a problem for us when we have lots of noise around us and we're trying to travel and we don't hear these hybrid cars or electric vehicles. They also create another challenge. And then we've had changes in the no-fault insurance in Michigan that have created a situation where if you do not own a vehicle, you only get $250,000 worth of coverage. So all of these issues have created, problems for us. And I just think that there's a need to review and update the white cane law and to also look into some of these other issues that are associated with the white cane law. And so, we do travel on foot, as Robert discussed. We do travel amongst our community. And I myself, as a mother, my children are adults now, but I traveled with my children holding my hand, crossing streets, going about our community like the rest of you would want to do. And so, again, it's very important that we just look this over and try to see ways we can improve it. My life is worth a lot, and I want people to be paying attention when they're in their vehicles and not texting and eating their fast food and all of those things that distract them and then take my life. And so I'm glad to see today that you all are looking this over. So I appreciate your time.
Thank you so much for testifying today. I don't see any questions from the committee members, so Carla, thank you for working with the sponsors on this. And if there are any additional questions or concerns, I can urge you to continue to do so. Members, we are now going to do some votes. We are going to start with Senate Bill 351 from Senator Irwin. Prohibits discrimination in a place of public accommodation or public service against an individual expressing milk. Oh, shoot, before I do that, I forgot to read in some cards on 5525. We have Mitch Elbers from the Michigan Association for Justice supporting the bill, not wishing to speak. Matt Breslin from the Michigan Veterinary Medical Association opposing the bill as written for 5525, not wishing to speak. Dr. Janet Donlin, American Veterinary Medical Association, opposing the bill as written, not wishing to speak, and encouraged us to read her written testimony. Are there any cards for Senator Irwin's bill? I don't believe so. Nope. Okay. Madam Clerk, please call the roll. Oh, I'm sorry. I'm going to take a motion from Representative Edwards to report Senate Bill 351 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards. Pass. Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Pat?
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 4 pass. Senate Bill 351 is reported with recommendation.
Thank you. We are now going to turn to House Bill 5328 from Representative Wilson. I have here a card from Judge Mike Carpenter, President of the Michigan District Judges Association, supporting the bill, not wishing to speak. Trevor Van Dyke, Deputy General Counsel for the Michigan Supreme Court, supporting 5328 on behalf of SCAO. And Neil D'Souza from the Office of Retirement Services, DTMB, putting in a card of no position. So, okay, I will take a motion from Representative Hope to report House Bill 5328 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Pass.
Wozniak.
Yes.
Outman.
No.
Johnson.
Yes.
Madam Chair, you have 10 yeas, 1 nay, 1 pass. House Bill 5328 is reported with recommendation.
Thank you, Madam Clerk. We are now going to turn to Representative Wozniak for testimony on House Bill 5110, the Unitrust Act.
Sure.
I understand you have a super exciting probate bill for us to discuss.
Oh, yes, another one of those.
It does not involve the rule against perpetuities, does it?
No, that was a couple months ago.
Okay.
But I'm glad you addressed that, though. Good morning, Board. What I'd like to say is the bill we had a couple months ago would encourage people to leave money in the state instead of sending it to other states for their families through the different descendants that they would have. This bill kind of does the same thing, but it does change the landscape of income trust versus a unit trust. So I'll keep my comments short, and then I'll introduce my favorite witness. Pleased to be before you today to speak in support of this bill, which creates a unit trust act. I'm pleased and proud to be the bill's sponsor. This is legislation that is finally tuned and championed by the probate and estate planning section of the State Bar of Michigan. who asked that I work with them to have it enacted. So I want to give credit where credit is due. So thank you to all of who contributed to the version of the bill that you have before you. My intent in sponsoring the Unit Trust Act is to modernize Michigan trust law. In the past, trusts have often had a clear delineation between income beneficiary and principal or remainder beneficiary interests. So that just means there's different levels of beneficiaries. While modern trust accounting requires greater flexibility, trustees now tend to invest for the highest total return and then adjust between interest and principal to produce a fair result for all beneficiaries. This legislation recognizes this trend toward total return investing and includes unit trust conversion rules to allow even older trusts to take advantage of modern investment trends. The proposed act gives estate planning attorneys additional flexibility to tailor a trust for each client's needs. Now, given that we are fortunate to have with us Mr. James Spica, whose legal practice is dedicated to representing and advising individuals and institutions with respect to complex trust planning, with the permission of the chair, I would like to ask him to provide a more technical explanation of the impact of the bill. Thank you.
Thank you, Representative Wozniak. Mr. Spica, welcome back. As with our other witnesses, I'm going to ask that you try to keep your testimony limited to about 5 minutes.
Thank you, Chair Breen, and thank you, Representative Wozniak. I am a member of the Michigan Commission on Uniform State Laws and the current chairperson of the Probate and Estate Planning section of the State Bar of Michigan. I need to emphasize that the latter organization is a voluntary association of practitioners and not the State Bar itself. We have about 3,500 members who are practicing probate, trust, and estate lawyers. The section created a committee to evaluate the possibility, the desirability, and the how-to of creating a unit trust statute, which is an adaptation that the committee developed of a Uniform Act, Article 3 of the Uniform Fiduciary Income and Principal Act. And that is what House Bill 5110 comprises. The problem that Representative Wozniak alluded to is one of fiduciary investing and the competition for economic benefits between so-called income beneficiaries and remainder beneficiaries of a conventional trust, a trust that would have been written anytime in the last 50 years, which treats beneficiaries as having successive interests, present beneficiaries being entitled to the income from the trust property, and future beneficiaries being entitled to later income or to the trust property itself when the trust terminates and the assets are distributed. The problem for the fiduciary is that she owes duties of loyalty to both sets, both kinds of beneficiaries, and that loyalty informs everything she does, including investing. And so she has to decide whether to invest for current return in the form of interest, dividends, rents, royalties, and so on, or for future appreciation. Investing in today's market will draw a sharp distinction between quality investments that produce one or the other of those things. Income, present income in the form of dividends, for example, or appreciation. A classic example is Apple stock or any tech investment. Dividends are very low, appreciation is very great. And what the fiduciary finds is that she can do the best for the group as a whole by investing not so much for income as for appreciation in today's market, but that creates a problem for the income beneficiaries who are entitled to her loyalty in the form of her attempt to generate a present return for their interest and benefit, and not just a return that provides appreciation to beneficiaries who will enjoy the trust assets later. The investment for total return that Representative Wozniak has referred to is the preferred method of a fiduciary satisfying her fiduciary obligations to the beneficiaries, and that will require her to make adjustments. If she has accepted in an investment plan that involves very low income, she will be distributing principal to income beneficiaries to compensate them. The trust instrument may or may not provide facility for doing that. If it doesn't, Michigan law does to some extent in Section 104 of the Uniform Principal and Income Act. But these discretionary acts are one-offs. Each year, the trustee has to decide how to adjust, in the name of fairness, the relative interests of income and remainder beneficiaries in the trust. That has caused modern trust drafting to admit the possibility of a different regime, unitrust investing, where investment is for a total return, and the present beneficiaries, rather than receiving income from the trust, receive a set percentage of the trust's assets, and the assets are valued periodically. But for an older trust, that was drafted before the modern investment environment occurred, there isn't that flexibility. And to achieve it currently, beneficiaries, trustees have to go to the probate court and reform the court. This bill would avoid the necessity of doing so by allowing trustees with notice to beneficiaries to adopt a plan of unitrust distributions and thus displace the contemplated division or importance of the distinction between income and principal for fiduciary accounting purposes and in the economic lives of the beneficiaries. If this proposal is enacted, Michigan will join a group of 36 states in the country that currently have some form of unitrust facility legislation to allow trustees with notice to beneficiaries to change an income trust, as it may be called in fiduciary accounting terms, to a unitrust in order to achieve the investment benefits I've described, but to do so by adopting a plan that the beneficiaries have a chance to object to, but more importantly, that secures their interests in ways they can be made to understand by the trustee. That's the goal of this legislation. The last feature I want to mention to you is it's facility only. It doesn't create duties on the part of trustees who don't have a duty currently to consider creating a unitrust or switching their income trust to a unitrust. It simply allows trustees who want to do that to do so. In provision of the bill, Section 4.6 of the proposal, it is specifically said that trustees do not have a duty to consider implementing or availing of this legislation in order to implement a unitrust regime. I'm talking very fast. I'm sorry about that. I wanted to stay within my time. If that time permits, I'm very happy to take questions. I thank you in any case for your attention.
Mr. Speaker, we do have a question from Representative Fink.
Thanks for your testimony, and of course, thanks to Representative Wozniak as well. I'm only beginning to learn about this, so I might have more questions during the course of the next, week or however long it takes us to get through this one. One of my questions would be if there is as I understand it, there could be a predetermined percentage of the overall value of the trust that would be distributed year over year. Is that my tracking? Can the beneficiary decline the distribution and leave that, or some percentage of what the otherwise directed distribution? Can they choose to decline the distribution and leave it in the trust?
There are some technicalities to that. Mr. Speaker, can you speak to that?
Yes, the ability to do that has nothing to do with this proposal. Any beneficiary, one who's entitled to income, according to fiduciary accounting principles, can say, I don't want it. The trust instrument will determine the effect of that declination to receive a distribution. And so it very much depends, Representative Fink, on what was contemplated for the situation, if anything, by the settlor of the trust in question. But the act, like the current regime that involves presumptively distinctions between income and principal, doesn't force a distribution on any trust beneficiary. The question, what happens when a trust beneficiary declines, is an open one to be determined with respect to particular trust instruments, particular trust provisions.
Thank you. Seeing no other questions and no further business before the committee and no absent members, we stand adjourned.